We did an analysis and we found that the biggest chunk of that money was going to lawyers, 10.6 billion. So you're saying, let's take money of the poor, give it to people. By the way, most of your colleagues, if not yourself as well, very opulent people. They would go into a place, drive a Bentley at the expense of claimants. And we see that just for filling forms. Where have you ever seen a social benefit scheme that works on suing the state? Where have you ever seen it? Because you must just claim. The administrator can't wiggle them around. They're allowing that. And we are saying, medical aid members, be more active in the management of your medical aid schemes.
Now, let's talk about the financial position of the RAF.
Yes.
But before we get to that, I find it alarming that it's not only lawyers who are, as you say, upset with the RAF.
Yes.
There is a whole range of professionals.
Absolutely.
Medical aid schemes and so on and so forth.
You know what I'm happy about?
Yes.
You are not saying there is a whole lot of claimants.
One more week, one more episode of the Professionals Network podcast with myself, Theo Mapheto. This is the podcast where we like what we say and we say what we like. We bring you professionals from all walks of life, from accountancy to law to medicine and every field that you can conceive of. Today, it's no exception. I bring you a good friend of mine who happens to be an enemy as well, Mr. Collins Letsoalo, the CEO of the Road Accident Fund. How are you, sir?
I'm okay. And, greetings to all who are watching. I won't call you an enemy as such. I think we might be professional allies or adversaries, but I don't think that we are enemies.
That's correct.
Yeah.
That's absolutely correct.
Yeah.
Now, you are the Chief Executive Officer of the RAF.
Yes.
You have been at the helm for the last 3 years or so.
4 years, including the time when I was acting for a year or so.
Yes.
Yeah.
I want us to discuss the issues systematically. So we start from the very beginning. When you took over the reins at the RAF, you started off as an acting CEO,
Yes.
if I remember well. And one of the very first things that you did was to remove panel attorneys. You had attorneys who were defending you in third-party claims. You removed them. Why? What was the reasoning behind that?
Well, that's the belief. The belief is that I came and removed people. I didn't. I think what people must be aware of was that the Road Accident Fund was collapsing. It was being said that it's the biggest liability after ESCOM. It was going to surpass ESCOM. Coincidentally, this year, which is 2023, the RNYP, the deficit was going to grow to 51 billion in this year. And that would simply mean that we wouldn't have money to pay for anything because our revenue is about 48 billion. And something had to be done to ensure that the organization remains sustainable. And we had to make changes. But when you make changes, when the Titanic is about to hit the iceberg, you do not just sit and move the deck chairs. It's not going to help you much. So we had to look at what is it that is driving this thing in the direction that is going, that is collapsing the organization. And we realized that the biggest issue is what we call administrative costs. Mm-hmm. Administrative costs of funds. As a fund manager, I've been a fund manager before. As a fund manager, your costs, administrative costs must be, if you're an efficient fund, around 7.5%. If you're inefficient, maybe 12.5% at the max. The administrative cost of the Road Accident Fund was sitting at more than 55%. Now, it means for every rent that you collect, you are paying 55 cents to people that don't need that money. The people that didn't need the money collected only 45 cents, which is the claimants. Then we did an analysis and we found that the biggest chunk of that money was going to lawyers, 10.6 billion. And that's when we started with that, because the first thing was we looked at it. 99% of the time the matters were settled, but it was costing us 10.6 billion. Then we said there is no need. We realized that we on our own, by driving this thing, it was more a litigious model. And our predecessors had did this to try and manage their cash flow. And managing their cash flow by kicking for touch and actually taking matters to court that ordinarily should not be in court. And of course, I mean, when you do that, people become upset. People that are used to getting the funds as the 10.6 billion was going to be reduced. Others were getting it. So the people that were getting it were lawyers. And of course, obviously, lawyers would be unhappy. But that's not how we started. We started by actually looking at the feasibility of the fund, looking at it and seeing how it's going to make sense and how can it be sustainable going forward. And the first thing was to reduce legal costs. And then you'll see it. I mean, medical aids are complaining now. Doctors are complaining because they probably thought of what people are saying and they took it for as gospel truth, that these guys don't want lawyers. It's not about that.
Now, that decision was taken 3 or 4 years ago, as you say. I want us to speak to the impact of it, because the lived reality, the lived experience of many attorneys is that RAF seems to be struggling to defend matters in court.
That's not true. I mean, when you say we struggle to defend matters in court, you are assuming that those matters, when they go to court in the right way. So, for instance, if you go and you look at what we have been presented as, for instance, set-down notices.
Yes.
Right. We receive set-down notices.
Yes.
It's either the set-down notices are not received by us, or the ones we received are not on the court roll. Now you ask yourself what happened there. So we will deal with that at the right time.
No, but I need us to examine that. Yes, so you're saying there are people who set down matters, because when you set down a matter, it's ready to go to court. Absolutely. It's ready to be heard.
Yes.
So what you are saying is that you have an experience of fraudulent set-downs.
There are a lot of fraudulent set-downs. In fact, people, remember, when you take a matter to court, one of the things we must say, what is trial ready or not? Most of those matters are not trial ready at all. When we started to say, let's settle these matters, because they knew our model is settlement-based, we said all these backlogs, bring matters that are ready for settlement to settle. They didn't bring them. And then they flooded our set-down emails and what we had put in place to flood it with things that are not ready to go to court, so that they create this bubble. Because remember, the aim of all these things is just to bring, one of the things is a summons generation machine that has been churning out summons even when they are not necessary. And how did they do that? They firstly brought matters that are not ready, not trial ready, even ready to be assessed by RAF to be able to make an offer, which is why you would see we then introduced the RAF Form 1. Because we were saying, but you give us 60 days within which we must assess this thing for validity, but you don't give us the information. How do I know? Now, that's why we then said, let's have a RAF Form 1, because the aim is to settle the matter. The aim is not really to do the claimant in. But I mean, a lawyer is paid on the basis of them going to court. Because if they just fill a form and then we respond, what will be the legal costs? And that is what the lawyer pays himself, by the way. If now it's 25% or your cost, whichever is lower. If you bring it today, I settle it. And let's just say in 30 days I'm able to settle. What would the lawyer make?
No, but I've got to defend lawyers here, because I know that lawyers are experiencing a bureaucratic delay of sorts from the RAF. Everyone wants to settle matters.
It's not true.
Why do you say that?
That is not true. The facts. Why lawyers would go and say RAF Form 1 is not necessary is because they don't want us to settle those matters. Because all we are saying is that give us that information that you would have given us in drips and drabs. Instead of drip feeding us, giving us in once, because that's the expectation. So, in law, right? So if you are suing someone today, which is the law in the law of delicts, as you know it. I mean, I'm not a lawyer, but I mean, if you are suing someone, are you not going to give them your full particulars of claim?
Certainly.
Why are you not wanting to give it to RAF? The very same way. You would give you full particulars of claim, you must do the same with the road accident fund. Don't drip feed us. If you come and you say, well, you owe me, I think the damage is 2 million, you justify why you are saying it's 2 million. It's not for me to tell you to justify it. But when you go to the other side, you give them the full particulars of claim. When you come to RAF, you don't want to do it. Why? Because you want to issue summons. Because the law says. And by the way, the RAF Act was written by lawyers. You can see it. You see it with Section 19C, isn't it?
Yes.
Yeah, so it was written by lawyers for lawyers. It was not written for claimants. So for us, it's important that when your child today, God forbid if you die today in a road accident and through not a fault of your own, and your daughter wants to be assisted, the RAF must make sure it happens within 30 days, if not less. Now,
but is it happening as we speak?
It won't happen because she's going to have to use a lawyer. And the law says she must use a lawyer. Because the law says, if you don't use a lawyer, we won't pay you. That's what Section 19C says. You know, you don't have to honor it because you don't use a lawyer. So your daughter must get the assistance as quickly as possible. Now, where have you ever seen a social benefit fund that needs lawyers? That does not become a social benefit fund anymore. Because to get a lawyer, you must pay. And this creates a situation where 25% of the money or whatever the amount would be is going to someone else. Whereas we are trying to say, this is a social benefit fund, our people must benefit from it. And those that are entitled, those who are victims or beneficiaries of victims, must actually get that money quickly. But lawyers are not going to agree with that for obvious reasons. They have written this law for themselves. For instance, a very funny thing, I've been in the state for a very long time. Where have you seen a procedure in an act? Procedures are sitting in regulations. Lawyers put it in the act so that every time we go there, they'll say, let's go to court, it's unconstitutional and all those things. When you are trying to change the things for the beneficiary, who is the claimant? Ours is that of the claimant. We are not interested in whether, I mean, if the claimant can decide, but give them the option. They don't have an option as we speak. They don't have an option as we speak. As I sit today, I can't help my own mother. I can't go to the road, come to the road accident fund and say, Mom has been injured, I'm trying to help her. Because if I'm helping her, then 19C says I'm a third party that is not a lawyer, and therefore
there's
I
a
can't
reason.
assist.
Is there no reason for that, by the way? Because people have to be assisted by people who are accountable to a regulator. Lawyers are accountable to the LPC. So if something happens, God forbid,
Yes.
a claimant has a right to go to the LPC if a lawyer has behaved unprofessionally or has misappropriated the funds. There's somewhere where a person has to go.
Yeah, absolutely shocking. I don't even think that you want to go to the issue of the LPC. The LPC.
Yes, it's a regulator
It's
that regulates attorneys and advocates.
And its efficacy. Who have they struck off since you know? How many people? I mean, we have reported 102 law firms that chout our money. We had to even go to the legal service ombudsman. Self-regulation just doesn't work. Because the people that sit there, I'll tell you, one of the members of this committee, the disciplinary committee at the LPC, is also accused of the very same thing, taking money away from a RAF claimant, for instance. This is the guy that must take action against the other people. He won't do it because he's next in the line. So self-regulation would never work. This thing of the LPC, yeah, there's a regulator, there is all that thing. It does not work like that. But what social benefit scheme works on the base of a regulator? Imagine if you wanted to claim from SASSA and people say, no, you need a lawyer because there is a regulator called the LPC to help you. It does not have to be like that. And that's all we are saying. We want to give you the opportunity to come to us if you want to. You must not be forced. In this case, people are actually forced, which is unfair.
My takeout from what you're saying is that the net effect of what you're saying is that lawyers are not should not be required when a claimant approaches the RAF.
Absolutely. We are saying, should the RAF not do that, you can exercise your rights in law like any other person. if SASSA does not do what it does, you'll exercise your rights in law. So I'm not understanding why lawyers want to be the people that are the first ones to enter a claim. Because in the first place, I mean, you don't actually go and get a lawyer for your friends, right? If we are really friends, we resolve our matters easily. Now, what government sits there and say, bring a lawyer to come and claim your social benefit? What government does that?
But Munarin, tell me here.
Yes.
Does this then explain what seems to be some hostile engagement with lawyers? There seems to be no love lost between the two.
Lawyers are upset, and they must be upset like doctors are upset. I mean, they're upset because they've been getting 10.6 billion and it's now being taken away from them. In fact, they blame us for the briefing patterns of government, that government has not been briefing black people and therefore that. But it's not even true to that extent. The top 20 law firms that we pay out of the road accident fund are actually lily white. I think there are two or so that are black.
You're talking plaintiff attorneys. You're talking plaintiff attorneys, people who claim on behalf of claimants.
Absolutely. Yes. But the ones that we've been using
were mostly black.
Yes, but they are black. But you can't blame us for the briefing patterns of the state. We can't take over the function of the state to make sure there's transformation. And this is where the BLA should be coming. Should be saying, any other SOE, how much are you spending on that? But as professionals, we must also be proud. I'm a professional. Yes. In this position, I competed with white people. Not that I'm saying that affirmative action did not happen, but I'm saying that you must be competent enough to do that, and people must actually go in other fields of law. You can't be sitting there and doing only third-party compensation. It doesn't make sense. You go to school for 4 years at least to earn an LLB to just come and fill forms. That's absurd. I wouldn't be happy doing that. So lawyers as professionals must take their claim. Black lawyers must have their fair share. But it can't be the road accident fund that does that for you. It can't be correct. Because what you are saying is we must take money that belongs to claimants to beef up the transformation agenda of the legal fraternity, which is not bad, as it were,
yes,
as long as they were not claimants in the space that are poor. So you are saying, let's take money of the poor, give it to people. By the way, most of your colleagues, if not yourself as well, very opulent people. They would go into a place, drive a Bentley at the expense of claimants. And we see that just for filling forms.
So at the center of your argument is that claimants should be prioritized.
Absolutely. And that's our battle. Our battle with anyone that you see is to say claimants must be prioritized and that they must get the assistance quite quickly at that. Now, let me tell you the counter to a lot of other issues. For instance, now, if I wanted to talk to the claimant today, and he came through Mapheto as a lawyer, Mapheto says, well, you can't talk to my client without speaking to me. When I speak to Mapheto, Mapheto charges me for taking the call. Don't you find that absurdity? I mean, the absurdity of me wanting to talk to my client, who is the claimant, but having to go through someone who's going to charge both of us. If the claimant then calls Mapheto, Mapheto is going to bill the claimant for that call. And then when I call Mapheto, Mapheto claims over. He's just sitting in between. We could be talking through a call center, me and the claimant. It could be that easy. I'm not understanding why people want to come in between us and the claimant.
No, but you're right to the extent that it should be the claimant's choice whether to utilize an attorney or not.
But he must have a choice.
Yes,
At this point, they don't have a choice because they must be told, for instance, bring summons in 120 days. How do they do that? I mean, I can bring summons myself. I don't have a right of representation. I'm not a lawyer, even if I can't draft summons. So what it means is we are just saying you can use anyone for as long as that person is a lawyer. That's what we are saying. You can use anyone for as long as that person is a lawyer. So what's the point? So I'm saying I want to be able to assist my own aunt. I want to be able to assist my own. I understand the rough law very well, but I can't even assist my own relatives. Because if I then come to the rough, they're going to say, well, Section 19C says you must not, are you a lawyer? No, then we're not going to pay this money. That's unfair.
Now,
Isn't it?
that segues very nicely into something that I want to touch on. When a person comes and institutes a claim,
Yes.
these requirements that you have since introduced, are they not onerous?
No, they were always like that. There is nothing onerous about them. We didn't bring anything that was not there. That
Now,
did not
now you do
require.
insist,
Yes.
and we have to talk frankly here, you do insist that people must commission medical legal reports.
Absolutely. They would have been commissioned even before.
No,
There's
no.
nothing. They would have been commissioned before. You just will do it later on because you would have issued summons. You want to do it after issuing summons. And I'll tell you why you want to do it after issuing summons. Because after issuing summons is then that you're able to bill your legal costs. Before summons, you don't have any claim to the legal costs. So that's why you are now wanting to claim that we are bringing something new. You wanted to do it after issuing summons. You were supposed to do it anyway. What are full particulars of claim in your view? What are these full particulars of claim that you should have brought to us for us to assess this and validate it within 60 days? What are these full particulars of claim except all those things?
No,
Because you must then tell us, this is a delict-based law, right? So
You substantiate
You
it.
must substantiate your loss or your damage.
Yes.
Yeah. And there must be wrongful act. So you must prove there was wrongful act first. And then you must say, as a consequence of it, there is a loss or a damage. And that must be quantified, right? So you must have done that.
Let's talk about that. An average claimant doesn't have the funds to consult medical legal experts.
Yes.
And you and I know that the costs would run into hundreds of thousands.
Should
right?
they?
No, but as matters stand now,
No.
right? So somebody has to have 100,000 rand to prosecute a claim with the RAF.
That's true. Not true at all. Not true at all. I don't think that that's true. We had direct claimants that were coming here and they did not prosecute and they didn't pay 100,000 rands. So in any event, by the way, the RAF Act allows you to come to us and ask for that to be funded. So people are saying it as if, yeah, you can come to us and say, well, fund this, I'm going to check this, and then we'll check, okay, there is a point at which there was wrongdoing. For instance, a person that is a passenger, we know that that person, at least liability in the main is ours.
But your experience must
tell
tell you that there are cases which have prescribed in your hands. Many cases
and
which
that's
have
the
prescribed in
point.
your hands.
And that's the point that we've been emphasizing. They prescribe in our hands because the law never anticipated that to happen. And that's what we are changing. And that's why I'm telling you that the law, in the way it sits, it says go to a lawyer. Because it prescribes in my hand because you are actually suing me. Where have you ever seen a social benefit scheme that works on suing the state? Where have you ever seen it? Because you must just claim. But you then have to sue me, and to sue me, you must produce all that evidence. And I'm saying it's not necessary. And that's why we are bringing all these changes that the legal fraternity is up in arms about.
So when all is said and done, this is a new iteration of RAPS. What do you have in mind?
No, there's no iteration of the RAPS. It's the amendment of the RAF Act to make it more claimant-centric. That's all we are doing.
As I understand, that was the objective of RAPS, was it not?
I don't know about RAPS. I was not part of RAPS in a more significant way. All I'm saying is that we looked at this and we said these are the changes that are required for the scheme to be sustainable. So if you want to see it as another iteration of RAPS, it's your view. If you look at where the point of departure has been, we deny the fact that everyone must be entitled, no matter fault or no fault. We are saying fault must still be part of the system because it makes sense to do so. If you go and you get drunk and then you crash your car, your beneficiaries must suffer the consequences of that. Like any other person that does things that are not untoward or things that don't make sense. And we are saying that we can't be in any state that will take care of people even when they're doing, especially given the history of South African road crashes and the road safety position of South Africa where it sits today. So you can't sit there and say, I'm going to pay for everyone. It doesn't make sense.
Now, let's talk about the financial position of the RAF.
Yes.
But before we get to that, you know, I find it alarming that it's not only lawyers who are, as you say, upset with the RAF.
Yes.
There is a a whole range of professionals.
Absolutely.
Medical aid schemes and so on and so forth.
You know what I'm happy about?
Yes.
You are not saying there is a whole lot of claimants. You're talking about professionals. And I've just told you that it's administrative costs. Even rough employees, some of them are not happy. Because some of them...
Why is that?
Well, the sheer part where some of them were captured by professionals in that sense. A lot of them would hide behind this panel. Why have you not done that? I gave it to the panel and all that. So, of course, they won't be happy about it. But what is the reality? The reality here is that the most important person that we should worry about, that wants the service, that wants the assistance, is the claimant. And this system is...
Accepted.
Yes.
Accepted.
So that's what I'm saying. If professionals are worried and then complaining, I'm not so much worried about it. I would worry when claimants are actually... claimants are very happy, by the way. A lot of them are happy.
That was my next question. Yes. Are you saying claimants are happy with what RAF is doing now?
Absolutely. Claimants are very, very happy. They are saying, these lawyers have been taking money away from us. They have been denying us the right to directly talk to the RAF. Now we can do it. They are very happy about it. Because your colleagues, when people get $1 million, I mean, it's a strange thing that we had one of the Free State judges being caught in this fraud of a young a child claimant, a minor, who was paid some 3.2 million, but only received some 1.2 million. And this was a judge. That person became a judge. And I'm saying to you, it doesn't get more worrisome than that, where a person who is a lawyer, who then gets appointed a judge, is one of the people that have defrauded a minor, someone that vulnerable.
Now, but you know, that's one experience. Yes. That's one part of the
experience. No. That is the majority experience of South Africa.
No, it cannot be.
It is the majority experience. And I'm telling you, today if we go out, there is no lawyer that has got a moral high ground.
But I also want us to touch on, do you have the wherewithal, the resources, the capacity,
absolutely,
as a RAF to handle these cases that come your way?
Of course.
Because the experience that I have, the information that I have is that RAF seems to be struggling.
That's the information you have based on what? I'm saying to people, the Auditor General audits us every year. They were here this year. They checked. What you are saying is not true. So there's the part where people come and they, I call it confabulations, because I suspect that at some point they tend to believe their own lies and then they go ahead and all that. But the reality is that that's not the case. The case is this. The Road Accident Fund is doing this. Let me tell you what the issue is. They are now bringing claims, all of them being rejected. 97% of all these claims that come through do not meet the minimum requirements in terms of what I told you, that full particulars of claim are not put through, and only 3% go through. And because the 97% we used to accept, we would sit with them and not be able to go through them, and we won't give you an offer within 60 days that is valid in all respects in law. Imagine that. Simply because you did not give us the full particulars of claim, the problem is rough. We write to you, you say no, but you have not told me that this is invalid. How do I know it's invalid when you have not given me, you have just given me a form without no particulars of claim or supporting documentation? And we are saying that must be clear. We need full particulars of claim for us to make. So assess us on the ones that came in and have all the particulars of claim. See how many we have given offers on.
If what you're saying is correct, if everybody is supposed to be happy.
No, but I haven't said everyone is happy.
Well, it's supposed to be happy from what you say, because
I'm saying,
it's a public institution.
Yes, I'm saying yes, but I'm not here to make people happy, by the way. That's not my job. I can't do that. I'm here to make sure that I implement the RAF Act, and that's what we've been doing.
Scopa was here a month or two ago.
Yes.
And the chairperson of Scopa was very scathing in his criticism of the RAF.
Absolutely.
That surely is a worrisome fact.
I am unperturbed by that. Very unperturbed.
These are people who oversee public accounts.
Yeah, absolutely.
They are worried about the state of the RAF.
Where is the public accounts in what they were saying? They came here, they talked about filing. What is the public account got to do with that? They say, there are files that are sitting in boxes.
But they
And
also
I'm saying,
talk about
but
staff
where should
morale.
they be?
They talk about staff morale.
What is the objective test of the staff morale? What is the objective test? Walking around and talking to a few people? We've got 3,200 employees here. So what is the assessment of the staff morale? What is the basis of the assessment? We gave them an assessment that is based on the value entrenchment and how people are happy about that. Most people in the road accident fund, we got more than 80% are quite happy.
Well, let's look into exactly what he said. They went to one of the offices, I think. Mainland.
Yes.
Right? They walked around, interviewed a few people, of course.
Yeah.
They were worried about the working conditions of the employees. They were worried about the filing system. It seemed to be in tatters.
Yes. And that's what they say. It seemed to be. And I'm saying we have the AG that also looks at that aspect of things. The AG has never asked for documents they can't find. They have looked at that. There is no tatters there. So I'm saying on an objective test, not politics. I can't argue with politics. If people want to, for the sake of opposition, oppose everything we are doing, they are at liberty to do that. It's their democratic right. I mean, they are politicians, they must say that. We are looking at the objective test. We look at the objective test. We have got 91.3% performance in the previous year. We have reduced the backlog. We have done better from a point of view. I'll tell you that the RNYP was supposed to sit at 51 billion, is now sitting at 9.2 billion. Now that must tell you that we are doing something good. We are not saying everything is hunky-dory at draft. There's no way we can ever say that. We will get there. But what we are saying is that there is no crisis here. The crisis is for the lawyers. They've lost, we have paid them 3.6 billion, so just take 10, so they've lost 7 billion only in the past financial year. The previous year, they've lost, over the past 3 years I've been, or 4 years I've been here, they've lost more than 25 billion. So they should have a crisis. We don't have a crisis at all.
There must be a crisis because you can't pay claimants immediately. It takes you 120 days or more.
180 days.
180 days.
It's not one.
180 days.
Yeah, but
even worse.
When I was not here, they used to pay them in 2,000 days. It used to happen 2,000 days. So why we stratified our liability by paying the oldest claimants first. So on average, we pay in 180 days. I don't think that's bad, given the part that I'm telling you. We would be sitting at 51 billion. Today, we are sitting at 9 billion. We have never received a cent from Treasury. In 3 years, we have not got an increase in the fuel levy. But the RAF is doing well. It still can pay claims. So when you sit and you say, well, there's a crisis, what crisis?
Tell me your thinking about the amendment bill that people are talking about.
I am for the amendment bill. I actually love it. I think it's the best thing that can ever happen to South Africans, and in the main, the claimant.
Why do you say that? Because
the claimant would not need a lawyer to come to us. That's the first part. The second part is that it will be based on what we call defined benefits. So you would know I'm amputated a leg, this is how much I get. It will be equitable in a sense that me and my helper will get the same amount. Now as we speak, I get more money than my helper. That is a regressive form of intervention that can be done by the state. With me, as a person that earns this much, I can insure myself. I'm not even so sure why I'm entitled to social benefits. And I'm saying, these are social benefits. The have-nots must be the ones that are given. I shouldn't. I can take care of myself. And you as professionals can take care of yourself. Why do you want to claim from social benefits? And that's all we are saying. We are saying that that would make sense. And I agree with that. I think the department did well. Of course, we went and recommended certain things. They've agreed with certain things. And I think they've done well in this bill.
So as matters stand, your overall view is that things have improved at the RAF?
No, not only my overall view. The view of the AG, who walks around and uses a methodology, is not in my view. It's the view of the AG.
Why are you losing so many cases in court?
Which many cases am I losing?
No, but
the Constitutional Court says I do not have jurisdiction. So what is losing there? What have I lost?
No. But let's characterize it correctly.
Let's read what it says. Maybe we must read what it says.
It was followed by a cost order. Who's meant to pay for?
No,
for
but
costs?
I mean, a cost order was saying we were asking for leave to appeal, but that does not mean you have lost. It does not mean you have lost. Let me tell you.
No, but you're playing semantics here.
No, but no, it's not even semantics. For instance, the 45A applications that we usually bring, we usually pay for the costs. But at the end, the people that are defending and fighting against us, we end up paying the costs. Does that mean that we were not successful? It's not true. You can't use the basis of cost as something that says that you were unsuccessful. All I'm saying is there is no point at which you can argue that what discovery says and our legal position has been changed by the Constitutional Court. The Constitutional Court did not look at the matter. And this is a simple thing.
Yes.
You must look at...
It wasn't meant to look at the matter.
The Judge Kumalo judgment is simple. It says medical aids have no right to claim from the Road Accident Fund, nor to their administrator. So that's a very clear position of the Road Accident Fund. We have been saying prescribed minimum benefits, emergency medical conditions, as per Section 7 and 8, I think Section 2910 of the Medical Schemes Act very clearly defines what prescribed minimum benefits are. And if you go and you look at what schemes are, medical schemes are actually social benefit funds. So you can't have a social benefit fund trying to defray costs by claiming from another. It just doesn't make sense. So we are saying our legal position still stands. The Constitutional Court has not changed that. So I don't understand why people want to make a fuss about it. Well, I've been saying this before, even before the ruling. I've been saying you are going to be very disappointed because even if the Constitutional Court rules that what was written by our acting chief claims officer at the time is set aside, we have written another one.
So are you saying it's a Pyrrhic victory for the medical aid?
Absolutely. We are not going to pay them. We are not going to pay them, not because we are saying, well, we are not, they said we must not use, that is what is in their notice of motion, that we want to set aside the directive. Yeah, this directive has been set aside, but for long we have not been using that directive to arrive at the determination. Our determination is based on our own assessment of your damages or claims to the claimant. We are not interested in medical aids. But if Mapheto, the view was that medical aids can claim, why are they not claiming from us? Why are they now hiring Mapheto and then going to the member and say, go and claim using Mapheto, and if you don't, we are going to terminate your membership? Why would you do that? That's absurd. It's absurdity of the worst order. I've never seen something like that, where someone comes and says, no, go and claim them. I am a member of a medical aid. I pay them. Yes. I don't want to come and claim from RAF if something happens to me. Why am I forced? Why am I forced? I don't want to. There is no damage, in my view. There is no a loss that I've suffered. I've paid the medical aid that they've done what is allowed, that is they're supposed to, in terms of the Medical Schemes Act and its regulations. So when they do that, why should I go and run after RAF for that? I paid them. I pay a lot of money, a hell lot of money to the medical aid that covers me. Yes. And I'm a member of that. I own that medical aid, by the way. That's something South Africans don't know.
Yeah, true.
So go and change those rules as members of medical aid. That's all I'm saying. Members of medical aid, go force this thing on medical aid to change this rule that says you guys must come here and claim for money that is supposed to be meant for the have-nots. That's why you joined the medical aid. You joined it so that you don't have these issues. Now you must run around trying to get money, and when it's in your hands, they say, hey, give it to us. It doesn't work like that. It's unfair. Okay?
Now, you're right that the medical aid schemes wanted to challenge one of your directives. And
No. It's not the medical aid schemes. It's discovery.
Yes. Yeah, well, discovery.
Yeah, just say discovery.
Let me be clear, discovery.
And it's not discovery medical aid, by the way. Yes. It's discovery health.
Yes.
A PTY LTD, which is an administrative.
Understood. Yes. Understood. Now, I want us to talk about these directives because none of your directives have ever found favor with professionals.
Why should they find favor? They are finding favor with the law. So if I sit here, my job, I think, is covered in terms of Section 12 of the RAF Act. Says I must implement the Act, then it gives me the powers to implement the Act. In part of implementing the Act, I then issue directives. And you are unhappy about that. It's neither here nor there because I follow the law.
But directives are meant to make the process a bit more effective.
Absolutely.
Is that not the intention?
That's what it does. It is making it clearer that medical aids have got no right to claim from us. That's what that directive says. Our directive says emergency medical conditions and prescribed minimum benefit. By the way, we are not saying at this point we are not paying everything. We are saying we won't pay prescribed minimum benefits, we won't pay emergency medical conditions that have already been paid by medical aids. That's all we are saying. People must not make it that no. No, we are saying that's the legal position. On other matters, we will pay because there is nothing that says that the prescribed, if this falls under EMC and it falls out of PMB, we will pay for it.
I hear you.
Yes, we will pay for it. Because remember, that one says without deductibles or co-payments. This one might have co-payments, it might have. Yes. So you would have lost as a medical aid member and we would then reimburse you for that. But we are saying prescribed minimum benefits and EMCA must not be part. And that's all we are saying. So people are then trying to generalize. No, they must not generalize. Our view is not general. It is based on the law, and we are saying PMBs and EMCs as defined by Regulation 7.
And you're saying to the extent that medical aid members are shortchanged
yes.
by their schemes,
yes.
they must be a bit more active.
They must. They must never allow themselves to be shortchanged. I saw Bonitas writing this thing to us and telling us that you must fight this new RAF Act. And I'm saying, well, what is this now? Who gave them that right? Did they take this to us as members? Did they even take it to us as members? So we cannot have a situation where we have got people sitting there taking decisions on our behalf without our knowledge. Did they even test with the membership of Bonitas whether they want to claim from RAF? And come in to say, no, this thing is going to make you pay more. Here's an interesting phenomenon. If you looked at the increases of this year, where medical aids came, CMS, for the first time doing their job, they said, no, you can't introduce that before we take a decision. But did you see what is interesting? Mm-hmm. Not one of the reasons that are put in there says RAF. Because that's not true.
A single one.
Not a single one of them. Not a single one of them says it's because of RAF that your contributions are now increasing. There's no such a thing. So what have they been telling you? That because RAF is no longer paying the risk pool and all those things. It's not true. So the reality is this. As medical aid member, you must understand the medical aid is yours. You know? All these people that you appoint, what
you're
do
a part owner, I see.
What do they call them? The
trustees.
The trustees. Mm. The trustees are voted to go and act in the best interest. Not of the administrator. So the trustees of discovery must go there and say, we don't want this thing. The administrator can't wingle them around. They're allowing that. And we are saying, medical aid members, be more active in the management of your medical aid schemes.
Another directive that attracted a lot of controversy.
Yes.
Is the one that relates to the payment of attorneys. So a matter is settled, the funds have to be paid into an attorney's trust account.
Yes.
You've insisted over the last 2 years or so that attorneys have to be tax compliant.
Absolutely.
Right. Now, if you are claim-centric in approach,
yes,
what does the tax affairs of an attorney have to do with an attorney, with a claimant? Because you must just make sure that the claimant is paid.
This is contrary to what you were saying. You said that attorneys are law-abiding. They've got the LPC as a regulator and they'll do right things.
To the extent that they are not, there's a regulator.
Yeah, that's fine.
To the extent that the tax affairs are not in order, there is SARS.
Yeah, go and ask the National Treasury this question. Do they allow an entity of state to pay money to a non-tax compliant
service provider.
Yes, you are also a service provider.
No, the difference here is that the attorney is acting at the pleasure of the client, not at the pleasure of the RAF.
No, I have also the same problem. I mean, everywhere I go, I must be tax compliant, otherwise money of the state will never be paid to me. So you can go and ask them that. Where we are saying is that you must be tax compliant. And what's wrong with being tax compliant, by the way?
No, I'm not.
Yeah,
I'm not.
so I mean, you wouldn't have a problem. You wouldn't necessarily have a problem with that provision. Why would it even? You are saying controversial. What is so controversial about saying you must be tax compliant?
No, but the point is more nuanced than that. The
Yes.
point is, the RAF should not arrogate to itself powers that it doesn't have.
Which powers are those? When the PFMA says before you pay, make sure people are tax compliant. Where does it say that this excludes the RAF? Give us that exemption.
Now let's take that argument to its logical conclusion.
Yeah.
Say an attorney is not compliant.
Yeah.
How would the poor claimant get their hands on the money?
Now, when he's not tax compliant, do you even want him to handle the money of the claimant?
No, but
how are you sure you won't even take that money and use it for his own tax affairs? So all you are saying is we must act blind.
I'm
take the
saying
money of the claimant and give it to someone who can't even control their own financial affairs. In a sense that why shouldn't you be tax compliant as an attorney? And you want money of the claimant being given to you. That will also be irresponsible of the RAF, let alone the PFMA. That will be irresponsible. I must give you the money when you are not even tax compliant. Why should I do that?
No, I'm saying there's a reality that we have to appreciate.
Which reality is this?
The facts are stubborn. The facts are that you could very well have people who are not tax compliant.
Yes.
Whether it's right or not, it's immaterial for the purpose of this discussion.
That's fine.
I'm saying a claimant should not be prejudiced because the tax affairs of an attorney are not in order.
Firstly, the claimant chose that attorney. It's not us. We don't choose an attorney for you. Right? You must choose someone. They chose that person. That person is not tax compliant. But that person is not tax compliant. We are not going to pay over that money to that person that is not tax compliant. It's like in cases where an attorney owes us. For them to be able to be on the list of people that get paid, they must be in good financial standing. They must not be owing the RAF any monies. So what I can say to claimants out there is that just make sure that the one that you use, you must say, give me your tax compliant thing so that you deal with tax compliant people. I will tell this claimants to say, an attorney that is not tax compliant is very dangerous. They can actually use your money for other things. So don't ever accept that. They must not come to you and say, RAF is saying they won't pay us because we are not tax compliant. It's not their duty. No. We are saying we are responsible enough and as an entity of the state not to pay money to someone who we know is in a difficult financial situation. Why wouldn't your tax affairs not be in order? If they are in order, then we pay you. There's no problem. So you shouldn't have a problem with that. Actually, as an officer of the court, you must actually make sure that everything in terms of the law is.
Why do you seem to be saying it sarcastically?
There's nothing sarcastic about you being officer. You guys run around, no, the officers of the court. Now I'm saying, as an officer of the court, live to that expectation. We expect officers of the court to act with a certain decorum. Please do make sure that your tax affairs are in order. You must not owe the taxman. Do you know that when you owe the taxman, you're actually withholding money that is meant for the poor in this country?
No, of course. I mean,
you're
talking to the ecosystem, to the greater ecosystem. Of course, people have to be tax compliant.
Yes.
People have to contribute.
But I'm just
to
saying
the tax
that
base.
as a person who is responsible, you must know that your tax affairs must be in order. Mine are in order. So everyone's tax affairs must be in order, including the attorneys, especially because attorneys are officers of the court.
No, the point I think that is being made is that it seems that when it comes to the payment of claimants, it comes to the payment of claimants, RAF seems to be shifting the goalpost every time.
You can move out of the way, Mapheto. What you can do is, once you say that, you say pay directly to the claimant, we'll do that. There's no problem. If the issue is the money that we have not paid, the suffering will be of the claimant. Move out of the way, allow us to pay the claimant directly, we'll do that. We'll do that. Because ultimately the money is going to the claimant. We'll do that.
Indeed.
And why are you not agreeing that we must do that? In most instances, your colleagues don't agree with it. We are ready. We are ready to pay. We are saying this one is not tax compliant, but we can pay to the claimant directly. And that we can do. So there's no problem with that. We are saying to claimants, if you tell us, you take away the right, and you say pay us directly, we will gladly do that. So the claimant must call our call center, 087-820-1111, and say, change that mandate, pay the money directly to me. We'll do that.
The last time I saw you, the organized profession had convened a press conference.
Which organized profession?
All sorts of...
No, just say LSSA. Why are you saying the organized profession? Just say the LSSA. Because everyone who was there is part of the LSSA, right? It was BLA, it was... just say the LSSA.
It was BLA, it was
the LSSA in all its formations, but just say the LSSA. It's not the organized profession.
But be that as it may,
yes.
They had convened a press conference. And I don't remember that you were invited.
Where?
At the press conference. But I saw you.
Where? No, but where?
It was at the press club.
Oh, the National Press Club.
Yes.
Okay. So I was told that you are coming. You are going to say things about me. I've got a right of reply. And I said, I'm going to go. And I went. If you wanted your own press conference, hold it at the LSSA offices. Don't go to a public platform where we are all allowed to respond. And why would you have a problem with me responding anyway? So, because I came and I responded. You wanted answers, you got the answers. I mean, I don't understand what the lawyers were unhappy about. Is it because I really trapped you proper there? So yeah, you were trapped proper there. You were shocked. You couldn't handle another professional giving it to you as you expected to give it to him. You came, you attacked. And when you attack, don't expect me to sit back and watch. I couldn't.
So you're not running away from responsibility?
I'll never, ever. When you call me, that's why I'm on this podcast. I'll explain myself until I'm blue in the face, but I'll explain myself. There is no decision we are taking at the Road Accident Fund that is not thought of. It is thought through. We go through a lot of iterations. We take it through legal comments and all that. Then we take a view, professional view. Okay?
I mean, in conclusion.
Yes.
What would you then say? Because I can tell you of many experiences of people who go to court and they take default judgment against
Absolutely,
the RAF.
yes.
The RAF is nowhere to be seen.
What do you mean
you've
is nowhere
expelled?
to be seen?
No, when you go to court, that's why default judgments are obtained.
Most of the default judgments are taken after you struck off our defense. It's not.
No, but precisely, it makes the situation even worse, does it not?
Yes, but I
because
mean, when you say we are nowhere to be seen when you have struck off my defense, what do you mean? I'm there to be seen. I had a defense, you struck it off. So when you strike off my defense and you come in and say you are nowhere to be seen, what do you mean? But don't strike it off because you are striking it off because you are playing a technicality to come and say no. I'll tell you. Majority, 97% of all our claims that we go through don't go through default judgment. Default judgments are about 3%. 3 out of 100. 97, done.
But the point is, when you say I don't need attorneys to defend me,
yes, you
better have your house in order.
But when I appoint an attorney, then the attorney is there. Does it guarantee me that my defense won't be struck off? There's no such. By the way, default judgment used to happen even when the panel was here. Go and check.
Very seldom.
No, it was not seldom. It was not seldom. I'm giving you the facts and I'm giving the stats. Give me your stats. I'm giving you the stats. I'm saying there is no much difference. It's just that this one is elevated because lawyers are upset and they want to claim that, no, this guy, we have got competent state attorneys doing their work. A lot of your colleagues have been bleeding through the nose. Overworked means what?
It means the following. Do they have the capacity to handle the volumes?
They do.
The volumes of cases that...
I'm saying you are driving... This thing is a fallacy of volumes. I've just told you that 3% only meet the requirements of what is called full particulars of claim. Do that and see. If you go to court now with no full particulars of claim and you want to sue someone, The court won't agree with that. Why are they agreeing?
They will laugh you out of court.
Yeah, but why are they not doing it in terms of RAF? Why are they allowing people to come in front of them without full particulars of claim? They should be asking, did you put full particulars of claim? No, go home. They're not doing it. Can't be my issue. And I'm saying we just implore on people to be fair. And we need fairness. If you are being fair, you will give us the full particulars of claim. What is your interest in not giving me full particulars of claim? Because you are representing someone who needs a service from us. So give me full particulars of claim, you will see the difference. But what you are saying about default judgment, it's a fallacy. We will tell you that a lot of things are settled even before going to court. That's proof enough.
Is that
Secondly,
true,
is that yes. It's audited. It's audited. So if you go and check and say, okay, how many offers did you make? How many were accepted? How many were rejected? How many ended up going to court? And we even know the law firms that actually go and take default judgments against us and all that. And we know them. Okay, so it's not all. It's not even in the majority, by the way. It's not in the majority.
In conclusion, your vision for the RAF next 5 years. Next 5 years we'll be talking.
No, but my contract ends in August 2025. I don't know whether I want to continue or not. I mean, I'll apply my mind to that. But I think.
How are the stress levels, by the way? For a position as weighty as being the CEO of the RAF?
No, the stress levels are high. Thanks to my wife. Thanks for people around me. Thanks to my family for allowing me to take this position. I walk around with bodyguards because of lawyers and everybody else.
Come on.
My family walks
because
around.
Because of lawyers, come on.
Absolutely. My family goes around with bodyguards. These things are done after a threat analysis. They don't just give you bodyguards. So the threat analysis showed that there are people that, well, there was an attempt, by the way, on my life. So it's a difficult thing. So there were attempts. And if I say one attempt, it's something else. There were attempts on my life because people are unhappy about what we do. But, you know, I'm an activist. I'll continue to be an activist. I've been grounded somewhere else in my other life. So there's no issue about that. I mean, you know, the former president used to say it's an ideal for which I'm prepared to die. Yes. So it's one of those things that as a patriotic South African, I'm here serving my people, and I'm happy doing that. And I'm happy that my family supports me. So that's why people, I see every time they look at me, I smile. It's because I've got a very good family that is behind me and doing everything in their powers to support what I do. And I'm happy and glad that they have allowed me to do this. I mean, from my mom to everybody else. You know, my children have allowed that. They are bullied at school because their father has taken away the money from some father that happens to be a lawyer. That's what goes through. I mean, my children go through a lot.
Oh, no.
And I'm very happy that they are maturing to the point of defending themselves against any bully. And I'm happy that they understand the value of being patriotic as a South African. So, how far are 5 years down the line? We've got a 2025 strategy. There will be another strategy to consolidate the gains that we have had in 2025. Whether I'm going to be there or not, it's a thing. I mean, you might apply and I'll compete with you for that, like I've done before. But I think we've done well, and I'm quite confident that the state is in the right trajectory. If this changes in the bill come, the RAF will be sustainable going into the future.
For my part, away from the noise that accompanies the RAF, I'm appreciative that you are willing to listen, you're willing to debate and protect and defend your stance. Yeah. I appreciate
it's not necessarily my stance, and this is what the problem is. People always make it about Collins Letsoalo. I've got a capable board. There's a new board. There was a capable board before then. There is a minister in there. There are colleagues of mine that work very hard to make sure that what you see
before your time, or slightly before you joined, there was musical chairs. There would be this CEO, that CEO. There was a lot of instability.
You must give thanks to the 6th administration of government that came and said, look, We need stability here from the board side and also from the executive side. So that has happened, and I think it will continue.
And that's yielded some positive
Yes,
results.
I think that, look, the sixth administration has been strong about governance and all that, and they were making sure that they're tightening that. And you must give it to them. No one wants to give them credit, but the credit is due to them. They've made sure that this thing happens. They've given us the support, and they've given us the direction in which we must go. And I think kudos must go to them. A lot of people want facts are something else. Others who want to play politics and all that, they can play politics, but the facts will always be there. And I think the facts are there to speak for themselves.
There you have it, the Professionals Network podcast, a platform where we like what we say and we say what we like. Mr. Collins Letsoalo, thank you very much.
Absolutely.